Good afternoon. I'm Sharron Close with Emory University School of Nursing, and it is my privilege to share this presentation entitled Adult Curiosities and Consequences, Culpability and Defense Dilemmas for Individuals with X and Y chromosome Variations. I do have a disclosure and disclaimer slide. I have nothing to disclose. Our session is informational only. After this pre-recorded session, there will be a live expert panel available to create some discussion and to answer some questions for the audience. We will not be giving any medical or legal advice. It's mostly for information. So basically, this can be a very sensitive issue for individuals who get into trouble and for family members whose loved one has gotten into trouble by exploring these adult/sexual curiosities. Especially when children are of a younger age and this exploration is of a sexual nature, they don't understand the risks involved related to engagement, receipt, or exchange of information that is considered to be, quote, adult entertainment. So risks and consequences climb when personal contact is made, especially in social media. So there are many risks with that. So in this session, we're going to talk about some of these risks and consequences associated with the activity, and then some dilemmas associated with trying to use specific medical diagnoses to mitigate this culpability. So this session is for parents, teens, and adults. So these are some quandaries to consider. So what exactly is culpability? It's the legal responsibility for a criminal act. It's the individual's blameworthiness or the quality of being culpable. Our X and Y diagnoses alone are not mitigating factors. However, there are some features of X and Y diagnoses that may contribute to mitigating factors, and we'll talk about that a lot in the panel, but a little bit now. And then, of course, age is sometimes a factor. So the features of sex chromosome variations that contribute to risk have to do with intellectual disability, although most people are from low normal intelligence all the way to normal intelligence. Some executive function issues where impulsivity is not quite offset with their ability to inhibit their behavior. Many have social cognition problems where they don't understand the language, body language, and spoken language of others. They can be very socially immature. And some of them have a lot of self-esteem issues, anxiety, and depression related to not being able to communicate and transact with others. So it's not any one thing. It's really the combination of these various features that can contribute to high or medium or low risk of certain behaviors. So here's the sex cells slide. It happens. The pursuit of adult curiosities is just in our world. We know that sex sells. It's definitely a media influencer. And sexual topics capture interest and they do entice and lure, especially susceptible individuals, to explore ideas for sexual satisfaction. And the modes in which these are procured are photos and videos, sometimes drawings, but it can also be words online in print or in text messages. And it can involve the communication between individuals, including the sharing of ideas about experiences, desires, and fantasies. Laws about sexual crimes vary by state. So I advise you to review or know the state laws about what sex crimes are in your location. Also be aware of the consequences for infraction. And usually, and depending on the situation, the age of the person who is the perpetrator would be possibly a warning, a misdemeanor, or a felony. And the difference between a misdemeanor and a felony really has to do with the severity of the crime And that is often determined by the legal system and specifically by a judge. Also become informed about the penalties for these infractions, because once the penalties are administered, there really is no going back. So I reside in Georgia, and all of your states have clearly laid out the types of sex crimes involving minors. And the ones that I'll review today are sexual exploitation of a minor, child pornography, obscene internet contact with a minor, providing computer service to exploit a minor, and electronically furnishing obscene materials to minors. So Georgia law says that a person commits the crime of enticing a child for indecent purposes when he or she entices or takes any child under the age of 16 years to a place whatsoever for the purpose of child molestation or indecent acts. Child pornography is defined as it is unlawful for any person knowingly to possess or control any material which depicts a minor or a portion of a minor's body engaged in any sexually explicit content. So this includes online files, videos, print materials, photographs, and other things. Prohibited also are online file sharing, which is also involved in the consumption of child pornography. The possession of it alone is illegal. Definitely producing or distributing child pornography, such as texting it to another person or saving it and attaching it to an email. Online chatting between adults and minors, general sexual exploitation of children, and also sexting. So what is obscene contact with a minor? So this is when someone knows that he or she knows that they will be speaking or transacting with a child or who they believe to be a child via a computer online service or internet. It may also be through a local bulletin board service, an internet chat room, email, or online messaging service. And this contact between an adult and a minor involves any matter that contains explicit verbal descriptions or narrative accounts of sexually explicit nudity, sexual conduct, excitement, or sadomasochistic abuse. And if these things are intended to arouse or satisfy the sexual desire of either the child or the person, this is a crime. Providing a computer service used to exploit a minor. Now, many of us do not own our own servers, but it is unlawful for any owner or operator of a computer online service, and that would include creation of your own website, internet service, local bulletin board service, or other electronic device that is in the business of providing a service that can be used to sexually exploit a child. And then electronically furnishing obscene materials to minors. So these include any picture, photograph, drawing, or similar visual representation, image or person. You can tell this was written by lawyers because it goes forever. It's extremely detailed, and it needs to be, because that's what the law hangs on, are these details. Any written material or oral matter that includes listening and contains material of the nature that's already described. And the offensive portions of the material to the minor are not merely an incidental part of an otherwise non-offending role, and that the material furnished to the minor is taken as a whole, lacks serious literary, artistic, political, or scientific value, and is harmful to minors in that it appeals to and incites prurient, which means a sexual interest. Electronically distributing these things is also an infraction of crimes that can be read here. And also know that when an adult is communicating with a minor, or perhaps they're communicating with a person who has portrayed themselves as an older teenager, we don't really know who we're talking to on the internet a lot. And sometimes entrapment can occur when law enforcement is the originator of the communication and hooks a person into believing that they're chatting with a 13-year-old person, or it has to do with this undue persuasion or incitement or deceitful means of committing the act, in which not the perpetrator, the person starting the communication may be an officer of the law. So here's some defense dilemmas. Do the specific diagnoses mitigate culpability? And the general answer to that is no. The court is going to want to know, is the individual mentally competent by court standards? Do they have a driver's license? Did they receive an education? What is it about them that excuses their behavior or their impulsivity? What is it about their condition that would contribute to this? And then what professional team needs to be assembled to inform a defense team? For example, medical doctors, a neuropsychologist, a psychiatrist, national experts in X and Y chromosome variations. But I hear often parents will call me and say, we can't find a lawyer who knows anything about X and Y chromosome variations. We can't find a psychiatrist who knows anything about this. So these are these teams are very difficult to assemble, and there has to be a lot of pre-briefing and debriefing done with the defense team if they're going to create an argument that features of this X and Y chromosome variation are contributing to this person's risk for having committed a crime. So what's the cost of these consequences? They're pretty terrible. Number one, humiliation for the individual and also for the family often. These fines are very heavy. They may come with incarceration, some jail time. Certainly, if a person is convicted of a felony, it could cost the loss of future employment opportunities. And in many cases, they will be unable to be licensed for certain professions. And then the financial part of this is pretty staggering. Legal representation in cases can cost in the hundreds of thousands of dollars. And many families don't have access to this. And so they may have to rely on a public defender. So what is our best prevention? Number one, education. And it doesn't matter how old the person is, educate from the very beginning about our digital footprint. We are being tracked for everything. Talk openly in the family that whatever you do online is discoverable. Be intimately aware of every aspect. Everybody knows what we're buying online. Everybody knows what we're buying in the CVS drugstore. And then as a family, practice thinking through the consequences. Well, if you did this and this was found out, how would this go for you and what would be the next steps? Thinking that an X and Y chromosome variation diagnosis will provide the get out of jail free card is not likely. So my takeaway message for you is, number one, prevent this from happening. Be very aware of the digital footprint and know that everything is discoverable. Files erased from your computer. Kids are very facile. They're very easy now with browsing history. They'll delete that so mom and dad doesn't know which websites they visited. It's still discoverable on your hard drive and your backup drives. And as you know, if you watch any crime shows, text messages and cell phone records and things that you buy in the store are all discoverable and can be used as evidence against a person in a trial. So after this has ended, We will then be joining a panel of experts, and we will be happy to entertain any questions that you might have for our panel.